Hey everybody, welcome back. In the previous video, we highlighted some of the legislative success secured by the civil rights movement, but we all know that there's a long history of policies restricting minority rights. Let's get right to it. So this isn't a history class, it's a political science class, but we have to go through some of the legislative and legal history of policies associated with violating minority rights. We're going to begin our story in 1896. Reconstruction is over, and states have been emboldened to violate the 14th Amendment by making laws to restrict the rights of Black Americans. In the infamous landmark case Plessy versus Ferguson, the Supreme Court upheld a Louisiana law that racially segregated train cars on the basis of the separate but equal principle. The court acknowledged that the Equal Protection Clause required equality, but they established the fiction that segregated schools, public transportation facilities, and accommodations could simultaneously be separate and equal. The case gave official legal approval to Jim Crow laws, which multiplied throughout the nation, severely restricting the educational, economic, political, and social freedom of Black Americans. More specifically, Jim Crow laws are state laws that legalized racial discrimination and segregation. They fly directly in the face of the Equal Protection Clause, but the Supreme Court repeatedly looked the other way. A handful of laws effectively snatched away the right to vote from Black Americans. The 15th Amendment declared that race could not be a barrier to voting, but then states successfully erected obstacles that prevented the vast majority of Black men and later women from voting. Many states introduced poll taxes, which required a payment in order to vote. They also introduced literacy tests, ostensibly a requirement that voters could read, but in reality gave discretion to the official to deny the applicant the right to vote if any answer in his judgment was incorrect. Since there were many poor and illiterate whites at this time as well, many states created grandfather clauses to establish a loophole to let white people who couldn't pay the poll tax or pass the literacy test continue to vote. For example, if you or an ancestor could vote in 1868, then you could vote even without passing the literacy test or paying the poll tax. Additionally, at this time, the South was the one-party South, dominated by Democrats. The party introduced the white primary, only allowing white people to vote in primary elections to choose the Democrat that would run in the general election. In reality, this was the only important election, since the Democrats dominated the Republicans in the South in those days, and Black voters were banned from participating. The previous video mentioned that a number of these policies were finally addressed through constitutional amendments, federal legislation, or Supreme Court rulings. We'll review them briefly here. For example, in Brown v. Board of Education, when the court used the 14th Amendment's Equal Protection Clause to strike down racial segregation in public schools. The 24th Amendment banned poll taxes, and the Voting Rights Act of 1965 banned literacy tests and other obstacles to vote. And the Civil Rights Act of 1964 used the Commerce Clause to allow Congress to ban racial discrimination in public accommodations and employment. On the other hand, though, the Supreme Court has at times used the Equal Protection Clause to uphold the rights of the majority. For this class, most notably in Shaw v. Reno. The court held that drawing congressional districts based only on race violates the Equal Protection Clause, even if the intention is to increase minority representation. This case highlights a debate that is currently raging at the Supreme Court over policies intended to increase minority opportunities. One side says that the Constitution is colorblind, while the other argues for a race-conscious interpretation. The colorblind interpretation says that any racial distinction, regardless of intent, is unconstitutional. Very simply, racial distinctions are forbidden, even if the distinction is to increase opportunities for people who have been historically discriminated against. Racial distinctions are not allowed no matter what. The race-conscious interpretation argues that racial distinctions made to harm minorities are in fact unconstitutional. However, this view contends that distinctions intended to increase minority opportunities are permissible. Both sides are arguing about the Equal Protection Clause, and they both raise valid points. Read the words. It says that states can't deny to any person the equal protection of the law. Giving preference to one group means disadvantaging another, says the colorblind side. The race-conscious side shoots back, yeah, but literally the point of the Equal Protection Clause was to promote racial equality. So how could a policy that helps people who have been discriminated against go against the Equal Protection Clause. Over the last couple of decades, this debate has played out most prominently around affirmative action. Affirmative action refers to policies that give preferential treatment in hiring and educational admissions policies to people from historically disadvantaged groups, most commonly based on sex and race. The intention of such policies is to address workplace and educational disparities related to race, ethnic origin, gender, disability, and age. But most commonly, race is at the center of the debate over these policies. If you're taking notes, you really don't need to know the names of any of these cases, so put the result for each one next to the bullet points under the section Limits on Affirmative Action. The big picture is that the court has slowly but surely narrowed the acceptable uses of affirmative action more and more over the past few decades. Spoiler alert, as of 2023, it's so limited that it's nearly gone. Going back to 1978, the Supreme Court ruled schools could not use a quota system in which they reserve a certain number of seats to people of a certain race or sex. For example, saying that 14 out of 100 seats are allotted to black students. Then in a pair of 2003 cases involving the University of Michigan, the court came close to striking down affirmative action, but Justice O'Connor chose a middle ground. So by a 5-4 margin, the court said that race could be a factor, but not the factor when admitting a student, and that schools could not award points for race. Basically, some schools create a point scale for their admissions decisions. 200 points for a 1200, 300 points for a 1400 SAT score, points for GPA, extracurriculars, all that kind of stuff. That's still allowed, but schools cannot award points for sex or race anymore. The major blow, perhaps the death blow to affirmative action, came in 2023 in cases involving Harvard and the University of North Carolina, in which the Supreme Court all but said universities can't use racial affirmative action policies anymore. Technically, the court didn't do that. They said that race-conscious policies must be reviewed with strict scrutiny, which is the highest level of judicial review. Most policies reviewed under strict scrutiny are struck down, as both Harvard and UNC's policies were. They didn't go so far as to say that a school could never find a way to constitutionally use race in its admissions policies, but it's clear that it would be extremely difficult, if not impossible, to do so. Alright, well that's it for Unit 3. Check out the unit review video, but until next time, this has been a LaMoney production. Thanks again for watching. I hope that you are having a great day. Like and subscribe, and if you need some extra help before your test, maybe check out the Ultimate Review Packet. Great study guides, lots of practice, and I will see you in the next video.